Speaking of secrecy, let's talk about Lori Vallow. Not surprisingly, the hearing for Lori Vallow that's set tomorrow, that's right, that's the hearing where they're going to argue for a new trial. Well, the request for video and audio recordings of the hearing has been denied. That doesn't surprise me. The only thing that surprises me that it may actually be held in an actual courtroom. I guess we'll still have to wait and see. Now, as you may recall, the defense filed a motion for a new trial, first alleging juror misconduct, some confusing instructions, and how the judge inappropriately allowed the prosecution to amend the charging document, the indictment, to a different subsection of the statute that the prosecution didn't realize their mistake for 2 years. And obviously that was denied just before the prosecution closed their case, and they realized the mistake. And the court even said, well, wow, it seems kind of surprising. Nobody noticed this over the last 2 years. Now, the defense said, hey, judge, we noticed it, and we've been asking for the last 2 years. Okay, judge, you told us this is the statute. The prosecution had said this is the statute, and they're going to argue that they prepared their defense based upon that statute. And then the fact that they got to change it is basically not fair. If I had been the judge, and a good judge would have said, nope, you're stuck with your statute. And guess what? Court could have granted a motion for judgment of acquittal at the halftime after the prosecution rested their case. But Judge Boyce allowed the prosecution to amend their case. I think that is the strongest argument, but guess what? It is going to be denied. No surprise here. Obviously, Lori Vallow has been convicted, and there's little doubt that she was involved in the conspiracy to kill J.J., Tylee, and Tammy Daybell. But it is a pet peeve of mine when the judge literally helps the prosecution at every stage of the process, and the prosecution is still wrong, and the judges help cover up for them. And that's what took place. I'll say it again. These prosecutors messed it up, and a judge with a real backbone would have spanked them down. Now, we want justice, but is it really justice for basically the prosecution and the court to say, you know what you have to defend against, and then literally they pull the rug out right before they end their case? It's just not fair. No, don't get me wrong. I cannot imagine Judge Boyce granting a new trial, although he certainly could he could say, we're going to do it in April 1st of 2024 when Chad Daybell goes to trial. He's not going to do that. He wants to get this case over with, and he wants to move along. Therefore, he'll let the appellate courts deal with it, which will probably not give it any substantive thought, and will say, what's the harm? I get it. I'm not a fan of Lori Vallow, but, like I said, if we let them railroad guilty people, then guess what? The government thinks that they can do it to the innocent people as well. To Bryan Kohberger, his public defenders are asking for additional time in which to file their notice pursuant to Idaho Code Section 19-519. Well, what is that? That is the notice of alibi. And his attorneys state that, hey, since he's been arrested, the prosecutors have disclosed 51 terabytes of information. Now, I'm not a computer guy, but I do know when they say, hey, you have 4 or 5 terabytes of discovery in your case, it's a lot. 51 terabytes is a ton of discovery. So they need time in which to go through these recordings and all this electronic information, which is probably going to be phone records, social media, everything that they found on the phone. So the defense is saying we need some additional time. So what is Idaho Code Section 19-519, notice of defense of alibi? Well, it states that any time after arraignment, before a magistrate upon a complaint and upon written demand of the prosecuting attorney, the defense shall serve within 10 days or at such different time as the court may direct upon the prosecuting attorney a written notice of his intention to offer a defense of alibi. And that notice by the defendant shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon with whom they intend to call to establish that defense. It also states that within 10 days after receipt of the defendant's notice of alibi, but no event less than 10 days before the trial, unless the court otherwise directs, the prosecuting attorney shall serve upon to the defendant or his attorney a written notice stating the names and addresses of the witnesses upon whom they intend to rely upon or call to establish that the defendant's presence at the scene of the alleged offense and any other witnesses to be relied upon to rebut the testimony of the defendant's alibi witnesses. Just the way it is. Now, Idaho is a little different. Everywhere I have ever practiced, the notice of alibi is usually due 35 days before trial. That's it. But you still have to provide the name, address, and phone number of anyone that you intend to call in that endorsement. But it's interesting that they, in Idaho, the prosecutors, are allowed to ask that up front, and normally there's no way that you can come up with that. Now, I can tell you, I don't think I've ever had an alibi defense. We've talked about this before. I've never had an alibi defense that worked. At trial, I don't think we've actually ever done it, because if it was totally rock solid, guess what? The defendant wouldn't be there.
And next on the docket, Amber Heard finally pays up. Yes, Amber Heard has finally paid the $1 million settlement that she owed to her ex-husband, Johnny Depp, after their somewhat bitter legal battle. Now, Depp and his ex-wife obviously settled their defamation claims against each other in December after 5 years of the long-going legal troubles that they had, and obviously the trial that was streamed last year. Now, while a judge in London found in favor of Heard, obviously the jury in the United States in Virginia came up on Depp's side. And after she was ordered to pay $10 million in compensatory damages and $5 million, which was later reduced to $365 in punitive damages, Depp was also told to pay $2 million in defamation damages. The couple came to an agreement. And now, so some 6 months from when they decided what they were going to do from this, Depp has finally received the $1 million. And according to Mr. Depp's people, he is going to divide the money up evenly, $200,000 each, across Depp's 5 favorite nonprofits. Apparently, the charities range from organizations helping sick children and life-threatening illnesses and providing housing for deprived communities. Now, Depp had always maintained that he was not trying to get any money out of his ex-wife, but simply trying to clear his name, where she obviously accused him of being a domestic abuser. The jury in Virginia rejected those claims, but still said that Depp and his attorney defamed her. So $1 million, the insurance company paid for the attorneys for her. Johnny Depp paid out of his pocket. It looks like it's a fair settlement. Now everybody can go away, and we never have to hear from Amber Heard ever again.
Please go to crimetalksearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to crimetalksearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. Next on the docket, let's talk about Lori Vallow. She had a motions hearing yesterday regarding her request for a new trial. How did that work out for her? Well, not so well. Obviously, the defense tried to argue the jury that convicted Lori Vallow of murdering her 2 children were influenced by outside sources. Lori Vallow obviously was found guilty of killing her children, J.J. Vallow and Tylee Ryan, back in September of 2019, after believing that they had somehow become zombies when she fell in love with Chad Daybell. Now, she was also convicted in regards to conspiring to kill Tammy Daybell as well. And anyway, the prosecutors argued that she became obsessed with the idea of this impending apocalypse, and the only way to save their children's souls so they could be among the 144,000 survivors was obviously to kill them. Makes complete sense, does it not? No, it doesn't. It's ridiculous. Most end of world stuff, kind of ridiculous, okay? I'm sure there will be an end of world someday, but I don't think anyone's going to be able to predict it. Just throwing that out there for you. Anyway, Lori Vallow's attorneys argued that the instructions given to the jury were confusing and that at least one of the jurors knew information about alleged crimes that were not entered into evidence. Remember, that was given in an interview with the press there in Idaho. Anyway, the retrial request was fueled by this interview that was given to the East Idaho News shortly after the trial was over. And in that interview, juror Saul Hernandez noted details about the deaths of Vallow's husband, Charles, that were not even mentioned in court. Well, Vallow's attorneys alleged that the changes in the original indictment should justify a new trial as well, which they argued was without proper notice from the prosecution. The prosecution countered that any changes to the indictment can be made at any time before the prosecution rests. Yeah, that's the law there, but you would think after 2 years you would probably notice that, unless maybe you were trying to play games. I don't know. I'm curious to see if the prosecution is going to amend the indictment statute in which they're proceeding on under Chad Daybell, if they intend to do that, or if they're going to wait until their last witness to do so in his trial, which begins April 1st in 2024. Anyway, Judge Boyce obviously presided over the trial for Lori Vallow and rejected the motions at the time in trial and rejected all of the defense arguments as it relates to a motion for a new trial. The judge said, yeah, no. Now, we've mentioned this before, but it's an oldie but a goodie. But what's the difference between a district court judge and God? That's right. God doesn't think he's a district court judge. District court judges do not admit that they made mistakes. That's what appellate courts are for. So if anyone thought, and I certainly didn't, think that Lori Vallow was going to get any relief whatsoever on this motion for a new trial. Rarely ever happens, and Judge Boyce is certainly not going to be so bold as to do that. Now, one of the things that the defense made a mistake in is that they never actually introduced the interview from the East Idaho News into the record. So it's not part of the record for the court to consider. And that's one of the reasons why the court noted that, well, there's nothing in the record other than you simply stating that this interview took place. A lot of people think, and sometimes attorneys apparently do, is that if they state it, it must be true. No, you have to have a hearing, call witnesses, introduce evidence for that hearing. Otherwise, it's not really part of the record. And you know what they call that when you don't do that correctly or properly? Potentially ineffective assistance of counsel. Throwing that out there. Anyway, the court's order was rather simple. The defendant's motion for a new trial is denied for the reasons stated on the record during the hearing. Boom. We're going back for sentencing end of July.